but to control the decedent's remains in conflict with the representation of people on behalf of surviving children, minor children like we have here?
Yes, but I believe that there was specific designation in writing that made it clear as to the decedent's wishes that we do not have here. I think that the case that's right on point here is Andrews.
So if you had a writing in this case, supposing that the decedent, instead of simply purchasing the cemetery plots, at the same time wrote out a piece of paper and says, "It is my desire that I be buried in this cemetery plot," would that then change your position?
Absolutely.
So that's really the key here, the fact that there was no writing in your judgment?
Absolutely. If there was a writing by the decedent, that of course takes precedence. Absent that, we have to look at who is a legally authorized person to make that decision.
Well, I think that's contrary to what we said in Cone, because there was an abundance of oral testimony as to her witnesses, as to her wishes, where she be buried. Judge Seidlin made a finding of fact, and we can't reweigh the evidence at the appellate level. But as I believe it was Judge Shayhood's question suggested, or Judge Stone's question rather, if she purchased a burial lot in the Bahamas, why wouldn't that be written evidence? There would have to be some piece of paper by which that burial lot was conveyed to Anna Nicole Smith or her representative.
The reality is there is a mystery in so many different avenues in this case. We don't know if she was under duress doing that. With Florida law,
allegation of duress or under.
Well, the law is clear, though. I mean, it needs to be an inter vivos writing. It does not mean the purchase of a cemetery plot. That is not sufficient. There's no case law that shows the decedent's intent.
When you're getting inter vivos writing, you're getting that from the two statutes involved. The one that tells a funeral director what to do and the one that tells a medical examiner what to do.
Correct.
Okay.
And
there's no place else in the law that you're pointing to.
Well, case law, interpreting that. I mean, there has to be some direction, obviously, what to do with the remains. There has to be some guidance, and Florida law and Florida statute makes it very clear what to do.
Okay. You have anything further? You still have 4 minutes. You can proceed with it or reserve it.
Well, Your Honor, this case has been absurd from day one. We have a mother who claimed the remains of her child. She's entitled. The law judge who mandated that an American citizen, she was not a resident of the Bahamas. There's absolutely no record evidence of that. That an American citizen be buried in a foreign land and that my client need a passport to go put flowers on her grave. That is absurd.
Wasn't there some evidence that she was either domiciled or a resident of the Bahamas? I thought I read something.
She never purchased property. There are no investments there. As a matter of fact, if you turn on the TV, the person that she was renting the house from is trying to evict Mr. Stern and the child.
There are a lot of things that may be outside the record in this case.
That is in the record, Your Honor.
Okay, but whether it's on TV or not. But if we're going to go there, the whole business with the Minister of Immigration in Bahamas fast-tracking her application for Bahamian residency, that was a done deal, wasn't it?
No, it was not. As a matter of fact, as part of the record, we have the fact that was canceled. The appropriate documentary stamp from the Bahamas was never issued. The money was never paid. She was not a legal resident of the Bahamas. Okay, that is in the record. But is
it not evidence of her intent to seek legal residence in the Bahamas?
Intent has nothing to do with it here.
If that wasn't her intent, if we maybe considered that intent might be a factor, then how do you explain the fact that she buried her son with whom she had such a close relationship there?
Well, she intended to bury her son there. It has nothing to do with whether or not she intended to be buried there.
Given the evidence in this record with respect to her relationship between her and her son, I mean, isn't that like a major elephant in this case?
Again, we're not going to dispute the facts here. The law and statute makes it very clear that the decedent's intent, until statute is changed, it doesn't mean anything right now. That would have to be changed. By Florida statute, her intent plays no part here.
You've got less than 2 minutes left, but you can still have your 2 minutes for rebuttal.
All right. Thank you, Your Honor.
May it please the Court. Mr. Carver, I'm here on behalf of Mr. Milstein, the guardian ad litem for Danny Lynn, Hope Marshall Stern. This case is not complicated. This case is not governed by the funeral home statute. And were it governed by the funeral home statute in the manner that Ms. Arthur would like it to be governed, the funeral home statute would be unconstitutional. Historically, next of kin is entitled to the right to determine where a deceased. Your Honor,
it goes without saying.
Yes, Your Honor. However,
ramifications of that.
However, there are lots of next of kin that are not of the age of majority, and this Court, to reverse Judge Seidlin under the extraordinarily high standard that applies here, would be to find that this one incident of being next of kin and minor would be deprived of the next of kin because she is a minor, and this one alone. A minor next of kin can take property. A minor next of kin can take stock. A minor next of kin can sell stock, all through a guardian.
The factors that would influence a guardian in that regard, though, would be decisions with respect to the best interest of the child, right?
Absolutely.
But in this case, it's not the best interest of the child that's really involved, is it? It's the wishes of the child. May or may not be in the child's best interest. It would be, but what we're looking at is what are the wishes of the next of kin, not what's in the best interest of the next of kin. Unless you just want to say automatically wishes equal best interest.
No, but the job of a guardian ad litem is to act as an adult in the stead of a minor. And it is the job of Mr. Milstein as guardian ad litem to try to...
How is a guardian ad litem ever going to figure out what a child would have wanted?
The same way a guardian ad litem acts in the best interest of the child. And in most situations, Your Honor, it might be complicated.
In most instances, a guardian acting on behalf of a child acts as a prudent person. In this case, you would have to have someone with a crystal ball.
Your Honor, you don't need a crystal ball. You literally do not need anything. All you need to do is look at one thing. Anna Nicole Smith buried the person she loved, most of all, in the Bahamas.
There's no question about that. And I rather doubt even Mrs. Arthur would have to acknowledge, and I think has acknowledged, that what her Anna Nicole's wishes are. But what is that? Are you saying then that the guardian ad litem for the child would be obligated to follow Anna Nicole's wishes?
I am saying that the guardian ad litem for the child should certainly take into account in determining the best interest of that child what were that child's parents' wishes. Anna Nicole Smith clearly wanted to be buried in the Bahamas. The factual record in support of that is not only not challenged, it is not challengeable.
Well, let me ask you a question. Does your client have authority and an option in this case to pick some other site for burial other than the Bahamas?
Judge Seidlin's order, his written order, was quite clear. It is in the sole and absolute discretion, guided by the best interest of the child, where the body from the medical examiner. Judge Seidlin could only decide who has the right to make the claim. Judge Seidlin could not decide where the body was to be buried.
I don't understand that.
He's a court of general jurisdiction in the state of Florida.
Because that was not the issue that was presented to him. What was presented to him was Mr. Stern's initial petition saying, I want the body. Ms. Arthur moved to dismiss that petition and filed a cross petition saying, I want the body. And Mr. Milstein, on behalf of Danny Lynn, filed a petition saying, I am entitled to the body under Florida law. The question before Judge Seidlin was not, where is Anna Nicole Smith to be buried? The question before Judge Seidlin was, which of these three claimants gets the body. Judge Seidlin properly decided that based on Florida law. Now, there are two cases that have been argued to this court as being either binding or not binding. One is Andrews, the other is Leadingham, and of course there's Cohen. Judge Seidlin certainly was bound by Cohen. He had no choice. Cohen says next of kin gets the body. Danny Lynn is next of kin. Andrews says the funeral home statute can help us sort this out. But Andrews is interesting because Andrews, among other things, says that the funeral home statute is consistent with historical Florida law going back to Kirksey and before. But the funeral home statute is consistent with Florida law except with respect to minors. And Andrews did not decide an issue with respect to minors. Andrews had adults in front of it. Leadingham
had minors.
Leadingham had minors, and the parties in Leadingham did not ask for a guardian ad litem. The court said, you should have. It would not have solved our problem because the ex-wife had 2 children, the ex-girlfriend had 2 children.
Wouldn't they ask, was there a request for a curator in that case, or was that a discussion about a request for a curator?
That was the dispute in that case, Your Honor. What had happened was the ex-girlfriend had been appointed the curator, and the ex-wife was not happy about that. The ex-girlfriend was going to bury, and the dispute was absolutely over the burial of the decedent's remains. That's on the first page of the opinion. And the dispute was, girlfriend said...
What would have kept Judge Seidlin in this case from appointing a curator, even though that wasn't posed to him directly that way, rather than giving all this authority to a guardian ad litem? What would have prevented him from appointing a curator?
Absolutely nothing, Your Honor. It would have been perfectly appropriate.
Pardon?
Absolutely not. I apologize. I spoke too fast. Absolutely nothing, Your Honor. It would have been perfectly appropriate. However, he did not. What he did do was the right thing.
Well, let me back up one step on the appointment of the guardian ad litem. I know the order refers to 61.403, but what authority other than what jurisdiction of the court?
Your Honor, that is...
Executor of the estate of Anna Nicole Smith, Howard K. Stein.
Preliminary question. You have no objection to us considering this as a petition for cert?
No, I do not. I agree with the Guardian's counsel that we believe if this case were even considered under the final appeal standard, the petitioner would have difficulty satisfying that standard. Given the appointment of the Guardian in this case, it would appear appropriate to alternatively proceed under the petition for writ of cert standard. This court should affirm the trial court's ruling appointing the guardian ad litem under the particular facts and circumstances of this case. The trial court correctly appointed a guardian for Danny Lynn because under established Florida statutory and common law, Danny Lynn is unquestionably the next of kin with respect to Ms. Smith's remains. The court is certainly aware of a half century of Florida common law in this jurisdiction, most recently affirmed by the Cohen case, whereby in the absence of testamentary direction in a testamentary instrument, the next of kin is entitled to possession of remains. The probate code here, section 732-103, establishes that next of kin is a lineal descendant of the decedent. Here, the petitioner is attempting to apply the funeral director liability statute, which Your Honor pointed out as a threshold matter, is not applicable to this case. The wrinkle that has occurred in this case is that Ms. Smith's body remains with the Broward Medical Examiner's office. That entity is governed by the medical examiner's statute. That statute provides that in the event that there are multiple claims from legally authorized representatives, that the remains shall pass according to the probate code 732-103. We pointed out in our briefs, and it's significant, the legislative history in this case that applies to both the funeral director liability statute as well as the intestacy provisions of the Florida probate code provide that if there are multiple claims with respect to a decedent's remains, they shall pass according to the laws of inheritance. We cited that in our brief. It's the staff analyses, and that clarifies any ambiguity here. You
even have to get to that point with respect to legislative intent if you just read the funeral director's statute.
Correct. The plain language of the funeral director's liability statute and the applicability provisions do not apply to this case. The reason why that provision is even involved in this case is that it's incorporated by reference into the medical examiner statute, and in the event of a dispute, it passes to the probate code. There is nothing in the plain language of the funeral director's liability statute that establishes that that statute was designed to essentially abrogate the intestate